Thank you. Good afternoon. It's my pleasure to be here and speak in this conference. I'd like to thank CMN for this invitation, and I would also like to take this opportunity and praise CMN for the great efforts to make legal and technical tools available for those who really need it, and Georgian government has also used their legal tools. So today I will speak about Georgia's cooperation law with ICC. Perhaps much more interesting topics would come today during this conference, but Georgia has attracted interest, especially its cooperation law, in light of the new investigation by ICC into the situation in Georgia. We have the Georgian government has started in the implementation of the Rome Statute and reforming its cooperation law from the early 2000s, when Georgia became the member of the International Criminal Court, and one of the earliest members of the court. And two benchmarks that Georgian government had when joining the court was to be as much simply accessible for the courts for cooperation as possible. And the other benchmark was the proceedings that should be carried out based on the cooperation requests should be the individuals involved therein should enjoy safeguards, procedural safeguards. How much simple it is for the court to access Georgia in terms of cooperation. The Georgian domestic law is largely aligned with the Rome Statute. Georgia is mostly monist country, not fully, but mostly. And it adopted the ICC Cooperation Act in 2003. And that act regulates Georgia's cooperation with ICC. It mostly repeats Rome Statute provisions, and in most cases it just refers to those provisions. Rome Statute, besides that International Cooperation Act, Rome Statute is directly applicable and prevails over domestic law in case of conflict. Also, judicial cooperation with ICC is much easier than interstate MLA, and the same is so with surrender. It's much more simplified, as I will talk in greater details throughout next slides. It's much more simplified than extradition. And substantive international law is directly applicable, even though the Georgian Criminal Code has very alignment with the Rome Statute. Still, it has special provisions where there is no there is impunity gap. It can be covered by substantive international law. It was required because dual criminality in judicial cooperation process and surrender process is a constitutional principle. And so, given that we don't have dual criminality as a principle, as a barrier for cooperation with ICC, also Georgian law allows types of cooperation not obligatory under statute. Those are, for example, witness and victim protection, as well as interim release. And we have to technically ease the cooperation process. We have designated single central authority, and that's Ministry of Justice. And that doesn't rule out the possibility to allow ICC cooperation with other stakeholders, like for example, the prosecution service and other agencies of Georgia. Surrender. So the surrender is very simple procedure under Georgian law. It's distinct from the far more simplified than extradition, and it's taken by administrative decision of the Minister of Justice, whereas extradition is subject to adversarial proceedings in courts. It's a surrender decision by the Minister of Justice can be appealed in court, but the appeals procedure is much more simple and far more brief than extradition proceedings. Person assault may also be provisionally arrested, and only very limited and perhaps hypothetical ground for refusal apply. For example, Georgia is bound to just a single bilateral immunity agreement, and that might be barring for surrender. However, in case of conflicting requests from other states, Georgia's cooperation law much reflects the Rome Statute. Judicial cooperation is also flexible with the court. By default, local procedures are used to render cooperation to the court. However, procedures that are requested by ICC and not specifically envisaged under Georgian law can be followed in the process of execution of judicial cooperation requests. And also, however, in this process, the basic fundamental principles of Georgian law must be respected, and those are mostly due process guarantees. As grounds for refusal are the sufficient information is not provided by the court and national security, but those two grounds are very constrained, and as the spirit of ICC ICC statute is to have consultations before refusal is given by the state, and so under the domestic law, Georgian authorities are obliged to exhaust all available resources through consultations. For example, Article 72, paragraph 5 of the statute is fully reflected in the domestic law of Georgia that envisages the possibility to reframe or modify the request to make it possible to grant it. Interstate MLA, in comparison, is much difficult, and quite a long list of grounds for refusal applies in those proceedings. As regards national security, national security, we have two guiding principles when it comes to the national security as a ground for refusal, and so those are necessity and proportionality. Necessity means that where even though certain information or documents are classified formally, if there is no longer a necessity, the Georgian authorities might review the nature of those documents and declassify that information. And also proportionality principle applies in the assessment whether to the specific national security information be disclosed to court. And so then the interests of justice should be outweighing to the national security concerns. Also, we have the obligation of national authorities to consult with court as to how the information can be shared, or how to perhaps in some cases the national security information can be shared without disclosing it per Rome Statute provisions. And also we have two authorities that assess national security. National security assessment. That's National Security Agency, which makes primary risk assessment, and then it's Ministry of Justice that finally approves this ground as a refusal. So it's kind of balancing approach between, so two authorities reviewed such requests, and so it's somehow safeguards while invoking this ground for refusal. As regards the overall safeguards of persons involved in cooperation process, it's fundamental that everyone who is involved in the proceedings subject to judicial cooperation must enjoy judicial oversight in this process. However, there are specific issues that Georgian courts have no competence, for example, challenge to ICC jurisdiction. In those cases, that issue should be referred to ICC chambers for consideration. Otherwise, the domestic procedures are subject to oversight and appeal by domestic courts. And due notification is also a fundamental principle in the process of judicial cooperation. Everyone who is affected by the request from ICC through the procedures must be notified by the domestic authorities of Georgia. However, there are certain grounds where this rule is waived when confidentiality is requested by ICC, but still, when the confidentiality needs are exhausted, the person must be notified about the procedures and him to be able to challenge those proceedings. So there are also requirements under ECHR, but that's more hypothetical in IC context. Safeguards are much greater when it comes to intrusive measures. Intrusive measures under Georgian law are searches, seizures, live interception, access to stored electronic personal data, and other sorts of personal information. And in the case of intrusive measures, domestic courts prosecution should apply to domestic courts to obtain warrants, and prosecution needs to demonstrate probable cause, and that's linkage of the requested measure to the crime being investigated, and reasons for believing that the object sought is located in a specific area, and that information must be provided by ICC through its request. If that information is not provided, Georgian authorities would seek that information additionally from ICC. Heightened safeguards are applicable to electronic data. Those cases, in addition to the probable cause, prosecution also must demonstrate the proportionality of that specific measure to the aims it pursues, and ICC should also provide that information to the Georgian authorities. Hearings for these intrusive measures are ex parte. However, after the execution of those procedures, for example, in case of electronic data access, persons affected by that procedure must be notified about that measure that it was enforced in respect of him, and they may seek invalidation of court warrant, and if achieved, that relevant data must not be used as evidence. Thank you very much.